Before the case even begins, this courtroom is already carrying years of tension. What looks like a simple landlord-tenant dispute is actually a legal maze involving multiple attorneys, jurisdictional limits, conflicting court filings, and a claim that may exceed $25,000, which instantly raises a major question. Is this case even in the right court? You're about to see a judge step into a case midstream, attorneys arguing over strategy instead of facts, and defendants who may have unknowingly walked themselves into sanctions territory. This isn't just about unpaid rent, it's about consistency, credibility, and what happens when arguments made in one courtroom come back to haunt you in another. Watch closely because this judge isn't just listening, she's tracking history, prior filings, and contradictions in real time. And when the word sanctionable enters the conversation, everything changes. Stay with us because the longer this hearing goes on, the more the stakes escalate financially, legally, and personally.
Jerome versus Cassidy. Well, hold on. Do I have everybody?
Mr. Cassidy is in Zoom.
Got it. I got counsel for the parties, Jerome's. I have counsel for Jerome's and for the Cassidys.
Yes,
right?
Your Honor, I believe we're appearing on behalf of the Jerome's plaintiffs in this case.
Yes. No,
Oh, okay.
Really? Boy, I haven't followed that along after the last 30 hearings. I get that.
Okay.
Okay.
I'm new. So
Yes, I do. Well, and that's what I'm saying. I said that's not Lloyd, so I don't know. But I was informed you're representing.
Eric and Paula Cassidy. That's correct.
So you're representing both.
I am representing.
Okay, good. So that has all come together. Trying to recall. Is Miss Tope going to be here?
I am not, I'm checking now, but I don't believe I have any communication from this. And she's normally pretty good about communicating.
It's nice of you to say it that way. So do any of you know with reference to Miss Tope?
I have not heard from her regarding this particular motion, Your Honor. We did serve her with the motion, and she's been otherwise in communication with me on other matters as recently as yesterday.
I haven't heard from Ms. Tope.
All right. So is everybody prepared to go ahead with your motion then?
Yes, Your Honor.
Okay, go ahead.
Okay. Thank you, Your Honor. The motion before the court is to the court to obtain concurrent jurisdiction over the monetary claim which exceeds the court's limit at $25,000, or in the alternative that the damage claim for unpaid rent be removed to circuit court. At the time of filing of the motion, it was all parties, and it was all parties through counsel's preference that this court keep jurisdiction to hear the monetary claim, given the long history of this case and the court's intimate familiarity with what's going on and how we got here. And it was thought amongst counsel that it was judicially prudent to keep it here instead of starting over in circuit court with a new judge. And so and the court had expressed in the past its willingness or openness to doing so. So I filed a motion to bring that to a head so we can move on. The parties have spent an inordinate amount of time trying to settle this case. It's not happened, and we're ready to move forward with.
This is a huge procedural moment that might sound technical, but it matters a lot. The attorney is asking the court to either take concurrent jurisdiction over a monetary claim that exceeds the court's $25,000 limit or send the damages portion to circuit court. Why does this matter? Because normally courts are bound by strict monetary limits. But here, everyone previously agreed this judge knows the case better than anyone else. Years of hearings, filings, delays, starting over with a new judge would cost time, money, and momentum. This is about efficiency versus formality. The plaintiff wants continuity. The defense, now with new counsel, wants time to reassess. And the judge, she's balancing fairness against frustration, and that tension drives the rest of this hearing.
With ultimately what is a rent issue from landlord's perspective. So we'd like the court to obtain jurisdiction if the court is willing, and also to move forward with trial. And I understand new counsel wants to clean up some pleadings, which we could be amenable to as well.
You have a position on this?
Thank you, Your Honor. Go from here, wherever.
Either.
First, I will say I appeared yesterday on behalf of the Cassidys.
Yes.
I'm relatively new to the case. As I see it from the docket, Cassidys have not been able to file a response to this motion. I also note that Ms. Tope is not here. Frankly, I think it would be helpful if we could continue this motion to just next week. I can file something by the end of the week.
Okay. So you need time to talk it through with your clients, figure out if that strategically is what you may want to do, and then do.
That would be very helpful.
Okay.
And while I'm making that ask, it'd be helpful if we could also amend. I know that the clients had filed a request to amend or leave so that they could file their answer to the last amended complaint. It would be helpful if I could also do that by the end of the week.
This is where delay fatigue becomes obvious. New defense counsel steps in and immediately asks for more time, which is reasonable in isolation, but context matters. The judge openly acknowledges this case has dragged on, with multiple attorneys rotating through. That's a red flag in any courtroom. Judges care deeply about efficiency and fairness, but repeated changes in representation can start looking like strategic delay. Notice how the judge carefully frames her response. She's not punishing anyone yet, but she's signaling that patience is not unlimited. This moment sets the tone. Fairness will be granted, but accountability is coming.
At the end of the week.
Well, let's do this. Since what I'm going to do is I'm going to adjourn this. I don't think, yes, this has been going on for a long time, but I'm going to adjourn everything, but I'm going to give you time to get to figure out exactly what you want to do. It would be nice if it were a case one could step into and just decide. I think counsel for the plaintiff is correct. I think that everybody was reported to me, got together and decided, yes, we want to kind of go along this path, and they were trying to sure things up. But in fairness, now that the Cassidys have one attorney, because I think, if I'm recalling correctly, I think throughout these proceedings, they've had separate attorneys for a number of different reasons. I'm going to give you an opportunity to do that and to clean up the pleadings. Have the two of you communicated with each other?
We just did this morning.
Okay, so extensive conversation.
So
No, that's okay. I think counsel for the plaintiff can give you certainly some background as to where it is, and then you could factor that in as to what you will do. All right. This is the second time I think we have actually technically been here on this motion, and I'd like to resolve it, but I also just want to be fair. So
I appreciate that, Your Honor.
you were going to say something else.
Yes, Your Honor, I understand, fellow counsel just arrived and his requests from his perspective are absolutely reasonable. But Your Honor, it could become exceedingly frustrating for the plaintiffs, the defendants to now be on their fourth counsel, which has led to a number of delays, late filings. And you're right, this is the second time we've been here on this motion, and we are very—
This objection matters more than it sounds. The plaintiff's attorney is preserving the record, making it clear they believe delays are unfair and costly. Why is that important? Because if this case escalates appeals, sanctions, fee requests, this moment becomes evidence that the plaintiff objected early and clearly. The judge acknowledges the frustration but still chooses fairness. However, she also makes something very clear. This is the last cleanup phase. That's judicial language for get it together or consequences follow.
Are very anxious to proceed and not continue to spend time and money while the defendants figure it out. And the prior adjournment was on December 2nd.
That's correct.
And it is now January 6th, and the new appearance from the new attorney was yesterday. There was plenty of time the Cassidys to do the things that they needed to do. I want to place an objection on the record, and if we're going to give the additional time to have that be the end of the time.
Yeah, it will be. And let me just say this, and I appreciate what you're saying in your objections noted that, but what the court is inclined to do, because we had all talked with the counsel, is do one of two things. If we could get jurisdiction over the whole case through order, then we could do that. But also, the court's understanding is I can hear the claims, award the judgment, and then somehow there's a process by which it is then certified in circuit court. So if it exceeded my jurisdiction, you just take that judgment and it's just signed off on by a circuit court judge. There's a process by which it can happen, and on a landlord-tenant matter, particularly. So that is the court's inclination. And I say that not ruling at this time, but I say that for your benefit so that you understand as you have your discussions. That's where I was going to head.
And I appreciate that, Your Honor.
Okay.
I will also note, I know that this was December 2nd. I know that there's been a statement that the Cassidys had a lot of time. I don't want to necessarily put it on the record. I'm happy to approach and
There are
explain.
issues with Miss Cassidy. Is that what you're? Yes. And I think we're all aware of that. And so I understand that. I mean, in a lot of ways, it was an odd circumstance because there were issues with an attorney who's not here today. We had to get through all of that. Then the Cassidys have two attorneys. That becomes the issue. And then one attorney, and I don't know the reason, I'm not saying it's bad or anything like that, for Mr. Cassidy leaves, but then another attorney appears, kind of, Mr. Lloyd. But Miss Cassidy, then that issue regarding her counsel had to be solved, and I'm not sure how that, I know what I did, but I don't know how that got resolved within the university. So a lot went on. So, and I appreciate it. I understand the time frame. I understand all of that. And this file just keeps getting bigger, and I don't have files this big. So, all right, so we'll do it. So how much, you were saying a week, are you going to be able to?
I mean, I don't want to delay this, inordinately. A week.
They're so
Fine, if
they're
you're
so
fine.
cute when they're young. No.
Thank you.
No. I can do this tomorrow. Anyway, no, but if you have to, you can, right?
If it helps, Your Honor, I'm not able to be back in work a week from today, but I could do it 2 weeks from today on the 20th.
Okay, so that you guys don't get behind somebody that, and I have no idea what's going to happen that day. And that Ann won't be here to calm me down if it gets bad. Will the 27th work for you?
Yes, Your Honor.
Yes, sir.
Well, okay. Let's do it that way. So I will adjourn the motion out by the 27th. You're going to get all of your pleadings and everything in order. Why don't you do it in case there needs to be any type of response? Could you do that in, say, 2 weeks?
Yes, sir.
Okay. So get all of that done in 2 weeks. So that way, if plaintiff needs to respond, they can.
Perfect.
All right. Fair enough. Everyone?
So hearing is adjourned until the 27th at 9 a.m.
Yes.
And then the revised pleadings would be due on the 20th.
Yes.
Okay, thank you, Your Honor.
And since you're the one causing the problem, can you prepare an order to that effect?
I absolutely.
Since you can do it. All right. Fantastic. All right. Thank you. Thank you, folks. Court calls the case of fixing housing 401k plan versus Erica Ward.
Good afternoon, Your Honor. Steve Etherly on behalf of Plaintiff Fixing Housing 401k Plan.
Aaron Ward, this one way. Erica Ward on behalf of ourselves.
All right. And we have a number of motions.
Yes, we have 3 pending motions, Your Honor. We have landlords MSD, we have tenants motion dismiss, and tenants, I've been calling it the omnibus motion because it's actually 3 motions in one.
And let's start with this notion of the omnibus. I understand what you're saying. Are you guys going to represent yourselves?
Yes, Your Honor.
All right. You know how to respond to a motion.
I would say best I can, yes or no.
All right. I don't know. Did you file,
File a response.
pardon?
I did file a response.
To the motion for summary.
Your Honor, we received that response.
Pardon?
We received the response.
Yeah, okay, now I see it. It's just, got it. Okay, what motion do we want to start with?
Wherever you'd like, Your Honor.
I really don't have a preference. It might be, I guess, if I take them in order of how they were filed, but I mean, whatever. What was yours?
I mean, selfishly, I would like to discuss my motion first. I think it takes away a lot of their arguments.
And let's go there.
Oh, that's fine. I agree.
Go, what?
Oh, I just said I agree.
Okay. Go ahead.
Your Honor, we have landlord's motion for summary disposition. I believe the briefing, like the lease language itself, is clear. The lease expressly provides that tenants must pay monthly base rent of $5,500 without any deduction or set off whatsoever. As this court acknowledged at the November 7th hearing, which we attached the transcript as exhibit E, the court correctly stated this lease language is not conditional. Tenants in their response completely ignore that lease language regarding the rent payment. Your Honor, going to the reply, the response, their sole defense is that this is a residential lease. I believe the argument is meritless. I don't like throwing this word around, but I believe it's also frivolous. Tenants admit in their filings, this court and the circuit court, that they're operating a commercial horse farm on the property Willow Ward Equestrian. Tenants don't reside on the property, and it's a business collecting money from boarders boarding their horses at the farm. I'm going to read paragraph 2 from the circuit court complaint. Erica Ward leases the property to conduct her business, Willow Ward Equestrian LLC, allowed on the property by the lease and Scioto Township regulations as an agricultural/farming use. Erica's business is an equine boarding and training facility, and then it continues. Your Honor, again, at the November 7th hearing, you acknowledged the commercial nature of this lease. It's a 7-year lease term that ends April 30th, 2028. Your Honor, you've read more leases than I have, but I have never seen a 7-year residential lease personally. Paragraphs 4 and 8B also support that it's a commercial lease. I'd also like to highlight in the circuit court, tenants individually are bringing a business interruption.
Can I just stop you for a moment?
Yeah, yes, sir.
Are you really arguing that this is not a commercial lease?
Yes, I'll be arguing that it's a residential lease and the landlord the entire time acted in harmony with us in residential lease premises.
Okay, but you guys aren't residing there.
We're not, no.
So what human being is residing there on those premises that could make this a residential lease?
The property is a little bit unique. The property includes an apartment with a furnace, right? Let's say observation. When we received the lease from the plaintiff, I mean, obviously I'm not.
Let me ask you this. Do you know what a residential lease means?
From the residential lease, I believe the onus of repairs are different. There are tax provisions that are different.
Well,
lease.
Customarily, yes. But maybe you need to understand that a residential lease can change, even if, let's say you're successful in the argument, which quite frankly, I'm having a problem seeing that it's a residential lease. Even if it were a residential lease for a period longer than a year, the parties can change the requirement of who has to repair. So basically what that would mean is this. Even if it's a residential lease for a longer period than a year, the term that you're complaining about wouldn't matter. The term is where the term is. That term could be in a residential lease, provided the residential lease is for longer than a year.
Sure.
Put another way,
Right.
the obligation to repair can be changed.
This is the legal fault line of the entire case: commercial lease versus residential lease. The judge dismantles the defense argument piece by piece. 7-year lease, commercial, business operations on site, commercial, separate guarantee agreement, commercial. And here's the key. Even if this were residential, the judge explains that repair obligations can be modified in long-term leases. That means the defense's entire strategy, withholding rent due to repairs, collapses either way. This is not emotional judging. This is textbook statutory interpretation, and the defense is visibly outmatched here.
Changed if the lease is longer than a year.
We have to be notified that the obligation to repair in the lease was changed.
Pardon?
Would the plaintiff have to notify us if the obligation to repair was changed?
It wouldn't be changed. It's just,
Because section 6 does state that the landlord should make all necessary repairs and replacements to property in common areas, including heating, air conditioning, electrical systems.
that's fine. The problem is you can't withhold. I mean, I'll let you make your argument. I just don't think it's going to get you anywhere. But go ahead, counsel.
Your Honor, I'm sorry, did you want me to continue?
Yeah, go ahead.
Your Honor, the parties also signed in addition to the lease, a separate guarantee agreement, which also evidences that this case is commercial in nature. Tenants make a good point in the lease also in our favor that the lease does not contain the normal plate statutorily required notices to a residential tenant. Again, this evidences that this is not residential in nature. Your Honor, even if they're trying to transform a commercial lease into a residential lease and are, impermissibly subletting or allowing someone to live on the property, that alone is grounds for default and termination of the lease. So if that's what they're arguing, that works in our favor because that is a separate ground for termination. Your Honor, the case law is clear that tenants may not withhold rent for repairs in a commercial context. I've cited these cases many times to you. They're cited in the brief and also attached. The unpublished opinion is also attached to the brief. I would continue that tenants are responsible for the actions of their former counsel in withholding rent. I should highlight, just for the record, in any subsequent, proceedings, Ms. Tope did file an affidavit attached to the response, Exhibit 4, that it appears to have just copied and pasted large portions of Mr. Ward's affidavit. It talks about how she signed the lease and how she works at Mr. Ward's employer. So I would just like to highlight that for the court. That was in response to our MSD.
Okay, thank you. Before I have you, who represents you guys in the circuit court matter?
Our attorney, Ms. Tope.
You realize that in these two proceedings, whether the representation is made by you or whether it's being made by your attorney, that you can't make inconsistent representations. You realize you can't do that. Huh?
She did not represent us in our other case?
No, that is not here yet. But you maybe I shouldn't use the word representation in this. You can't say one thing in one case
Correct.
and another thing in another case.
Understood.
So I'm to understand, and while you guys may not have said it yourselves, but have said it through an attorney, as I'm to understand and what I see, your attorney, Ms. Tobe, has made the representation in a circuit court matter that this is a commercial property.
In fact, I'm not going to disagree with you.
Okay,
I don't know.
now,
Not.
pardon?
I don't know if she's made that.
But you, okay, folks, this is where, listen, this is where the problem comes in with you not being represented by counsel. Because if you're going to, and I'm going to give you one break or as many breaks as I think are appropriate, but if you persist in it, there's going to be problems. Because if the representation has been made that it's commercial property there, and then you're left to argue before me that this is a residential lease, that's going to be a problem, a sanctionable problem. Because I almost have to believe that if you're arguing that, you're arguing that in bad faith. I'll put it another way. If you two were attorneys, and you came and you know in another action that you're making an inconsistent argument, and I'm not saying inconsistent arguments can't happen, but if in one proceeding you're characterizing something one way, and then in another proceeding characterizing it a different way, if there were a single counsel doing that, I would have very little tolerance for that. And I would be sanctioning. Meaning every time that representation is made to me, you're going to either have to pay the court or you may have to pay attorney fees to the other side.
This is one of the most dangerous moments for any litigant. The judge isn't just annoyed, she's issuing a formal warning about bad faith representations. Courts absolutely do not tolerate parties saying one thing in one court and the opposite in another. That's not a technical mistake, that's a credibility issue. The judge explains exactly what sanctions could look like: court costs, attorney fees, or worse. And when she says she would sanction an attorney instantly for this behavior, that tells you how seriously she's taking it. At this point, the defense isn't just losing the argument, they're fighting to avoid punishment.
I understand.
Hold on a second. Do you realize that's where you guys may be headed?
Yes, based on your statements, your judge, I have no reason to not realize that, yes. The only way I can realistically do is talk to Ms. Tope and say, to verify, she's the attorney who followed her guidance the entire time. But I 100% answer everything.
Folks. She's out of this.
Correct. Yes.
You're now before me arguing this case. I won't be sanctioning her. I will be sanctioning you. Because when it comes out of your mouth, you're stuck.
And your advice is what, Your Honor?
I don't really have advice. Look, folks.
So in this case, Your Honor, my argument, of course, was to comment on the residential aspect of the lease. That's what I was planning.
So
I'm not going to say
here's where I have to stop you, because there's been documents filed on your behalf in a different court, albeit you're represented by an attorney. They're really your statements, right? Saying something different than the two of you right now are going to say, I anticipate are going to say to me, okay?
I'm doing my, I don't want to yell at you guys. I don't want to sanction you. I really don't. I can tell you right now that if you had the same attorney was doing that in two different courts and I was aware of that, I rarely lose my mind and go off. Well, I'd probably do it more than I should. But anyway, I would be going crazy. And I would be holding their feet to the fire and making them explain in detail to me how they can have these inconsistent positions. Because here becomes the problem, folks. If you're making that representation, you're probably doing one of the most serious things that a person should not do to a court. And that is that you're misrepresenting facts to me, or you're just out and out lying to me.
I am doing neither, Your Honor. I did not realize that she represented us in the other court in a commercial matter. First I'd heard, so it never were shown before a judge, and I understand what you're saying, but I did not realize that. I read the statements. I'm not obviously an attorney, but I did not see that, that she had done that. Of course, I would not represent the case two different ways in two different lawsuits, and I'm not an attorney to begin with.
Yeah, but you understand the predicament you're in right now?
Oh, I do. You made a quick
Because if you start that argument, and if you guys want to represent yourselves, I'm going to hold you as accountable as I would an attorney.
Is it possible for us, knowing this, because obviously we don't have an attorney, to get an attorney at this point, or is that not possible?
You can always get an attorney. Sometimes you can walk out in that hallway, throw a stone, and you'll hit one. You can always have an attorney. But I don't know how many times I've adjourned it for, well, I've adjourned it a number of times. Tried to give you caution about your representation, and then gave you an opportunity for you guys to make your own decision about
This exchange is painfully instructive. The judge makes it crystal clear: self-represented parties are held to the same standard as attorneys. Good intentions don't excuse inconsistent filings. Confusion doesn't erase sworn affidavits. Once something is filed, it's a representation to the court, period. The defendants are now realizing that what felt like doing the right thing legally may expose them to sanctions. This is why judges repeatedly warn litigants: courtrooms are not places to experiment. The shift here is subtle but devastating. The conversation is no longer about rent. It's about truthfulness to the court.
about how you were going to proceed. Well, let me ask you this, just stepping aside from the motion. Why don't you have an attorney?
I believed 100% the whole time. Everything's being,
Pardon?
I couldn't see a possible way we did anything wrong. Of the case we're talking about, of the water heater, of the gas leak, and trying to protect people, I didn't see as possible that we did anything wrong. We've done, you have people living in a place, there's a gas leak, I'm just trying to protect them. The hot water heater sits 5 people or someone sleeps. So replacing it in a process been established. We've done this before. We had it fixed, paid, took my out lease. It's the same process. I could not see a scenario where me trying to get something fixed to protect a person from a gas leak was wrong. I couldn't. We've done it before where we've taken my out lease to fix other repairs. Like,
Folks,
that's why I didn't get to it.
yeah, but if you're renting that property,
Not renting to anybody.
somebody's just there.
They're there for free. My daughter stayed the night there. My wife stayed the night there. It's boarded to stay there. But the hot water tank sits within 5 feet of an observation room, and I could smell gas. And I just wanted it fixed. So dangerous. I don't know. I didn't think I did anything wrong.
But here's what you need to understand. And this is where it gets kind of weird, but just based upon the scenario you've given me, whether you're charging them or not, you would effectively be subletting.
Just friends with the people living there. He's stored his deer head in the place.
I hear you, but if they're not, you can't do both. You can't analogize this to a residential circumstance because you're creating a residential thing and then not claiming that they're really subletters or akin to subletters. I mean, you're going to have a problem, folks. You're going to have a problem. Now, if you truly believe that this is residential, then first of all, I think you're going to have a problem and you're going to subject yourself to sanctions. But if you in your heart and your analysis believe that this is residential premises, then that means somebody on your behalf in circuit court has not told the circuit court the truth.
I see the problem.
And then you're going to be subject to sanctions. And folks, when you filed these documents, or even if they're filed, you realize that you're representing that the information contained in there is true.
Mm-hmm. It is. I do realize that.
And do you realize that if I find that it's not true, what I can do?
Mm-hmm.
I don't think you understand.
No, I don't know what the sanctions would mean. I've tried to do things the right way.
You've risen. What do you want to say?
Your Honor, I was just going to say they already rang the bell by filing this response with both of their affidavits, with Ms. Tope's affidavit. I'm not recalling if one of the other boarders also is veering to whether it's a residential lease. But I'm saying they've already rang the bell on sanctions.
I know.
And the sole defense to our MSD is that it's a residential lease. Whereas in the circuit court, they're also bringing a business tortious interference claim and seeking lost profit damages for their business. So that's where we're at, Your Honor.
Want to say anything else?
No, Your Honors. Obviously, another court filing against my attorney.
Pardon?
In the other case, opted filing against my attorney. I'm not going to say anything that would get myself sanctioned. I just try.
Well, you already have.
Well, I realize that.
That's the problem, folks.
Any further help with that?
And Mr. Ward, I realize you're speaking. Mr. Ward, is there anything you want to say to me?
I'm comfortable with her representing me.
Do something a little bit unusual. I will rule on this motion today. I'm going to talk to the parties separately, unless there's a strenuous objection from either side.
No. Any
objection? Could you put them into my jury deliberation? We can go off the record.
By the end of this hearing, the judge has made her position unmistakably clear. The lease is overwhelmingly commercial in nature, rent withholding is not legally justified, and inconsistent representations across courts place the defense in serious jeopardy. While the judge shows restraint and patience, she also lays the groundwork for sanctions, making it clear that credibility, not emotion, decides cases like this. This courtroom didn't explode because of drama, it escalated because of contradictions, delays, and legal missteps. And those are lessons every litigant should take seriously. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.